Before we begin, a quick and important disclaimer. The following content is for educational and entertainment purposes only and does not constitute professional legal, financial, or psychological advice. Marriage and divorce laws vary significantly by state and are subject to change. The historical and statistical data presented are intended to provide context and do not reflect the specific circumstances of any individual case. You should conduct your own due diligence and consult with a qualified licensed professional in your jurisdiction before making any decisions regarding your personal or legal affairs. For most of American history, if a man wanted to end his marriage, he didn't just need a lawyer, he needed a villain. Up until the mid-20th century, you couldn't just walk away because you grew apart or the spark died. You had to prove in a court of public record that your wife had committed a specific egregious sin, adultery, extreme cruelty, or desertion. If you couldn't prove she was the guilty party, you stayed married. Period. But fast forward to today, and the landscape has inverted so completely that 70% of divorces in the United States are now initiated by women, a number that climbs to nearly 90% among college-educated couples. We are living through a massive, unprecedented shift in the domestic power dynamic that has left millions of men asking the same question. How did we get here, and why does the system feel like it was built for a world that no longer exists? In this deep dive masterclass, we are peeling back the layers of the American divorce machine. We are going beyond the surface-level complaints you hear on podcasts and looking at the actual historical tectonic plates that shifted under the feet of the American male. Over the next 10 parts, we are going to trace the evolution of the male experience in the American domestic court system, from the era of fault, where men held almost all the legal leverage, to the no-fault revolution of the 1970s that changed everything, to the modern-day complexities of silver divorces and the evolving definition of alimony. This isn't just a history lesson. It is a roadmap to understanding the potential outcomes of the modern legal system and a case study in how social engineering has reshaped the American family unit. By the end of this series, you will understand the hidden mechanics of custody battles, the financial reality of asset division in a dual-income world, and why the breadwinner model is currently undergoing its most painful transformation yet. To understand where a man stands today, we have to go back to the 18th and 19th centuries, a time when divorce was less of a legal process and more of a legislative act. In early America, marriage was viewed through the lens of coverture. This was a legal doctrine where a woman's legal rights and obligations were subsumed by those of her husband. Under coverture, a married couple was considered a single legal entity, and that entity was the man. While this sounds like a position of absolute power, it came with a heavy, lifelong burden of permanent maintenance. Because a woman effectively could not own property or sign contracts, the man was legally tied to her survival for life. Divorce was so rare and so stigmatized that in some states, you actually had to petition the state legislature to grant a private act just to dissolve a single marriage. For a man in 1850, divorce wasn't a new beginning. It was a public admission of failure that often resulted in social ostracization. The law focused on fault. If a man wanted out, he had to demonstrate that his wife had breached the marital contract in a way that the state found inexcusable. If he was the one at fault, say he was caught in an affair, he didn't just lose his marriage. He often lost his standing in the community and faced significant financial penalties that functioned as a form of lifelong punishment. This created a culture of performative stability. Men and women stayed in broken, sometimes even toxic situations because the legal exit door was locked from the outside by the state's moral police. The first major crack in this system appeared during the Industrial Revolution. As men moved from farms to factories and urban centers, the traditional family structure began to strain. We saw the rise of migratory divorce. Men who had the means would travel to divorce colonies like Sioux Falls, South Dakota, or later Reno, Nevada. These jurisdictions realized there was a massive market for men who wanted to bypass the strict fault laws of the East Coast. They lowered residency requirements to just a few weeks. A man could move to Nevada, live in a boarding house for 6 weeks, claim his wife back home had deserted him, even if he was the one who left, and get a decree that was legally binding. This was the first time in American history where divorce became an industry, a precursor to the multi-billion-dollar legal machine we see today. However, the most significant shift for men occurred not in the 1800s, but in 1969 when Ronald Reagan, then governor of California, signed the Family Law Act. This introduced no-fault divorce. Reagan later called this one of the biggest political mistakes of his life, but at the time, it was pitched as a way to reduce the perjury and theatrics of the courtroom. Before no fault, Couples who both wanted out often had to fabricate stories of adultery or abuse just to satisfy the judge. They called it collusive divorce. No fault was supposed to make things more honest. Instead, it fundamentally changed the contract of marriage for men. Under the old system, a man's role as the provider was protected by the fact that his wife couldn't leave without a specific reason. Under no fault, the unilateral divorce became possible. One partner could decide to end the marriage for any reason, or no reason at all, and the state would facilitate the split of assets and custody. For the American man, this meant that the traditional trade-off, providing a lifetime of financial security in exchange for domestic stability, was no longer backed by the law. We must also look at the data regarding the tender years doctrine. Historically, if a divorce did happen in the 1800s, children were often viewed as the property of the father because he had the means to support them. But as the 20th century progressed, the legal pendulum swung violently to the other side. Courts began to adopt the tender years philosophy, which presumed that mothers were inherently better suited to care for young children. This created a century-long precedent where men were relegated to visitor status. We are going to examine how this specific doctrine evolved into the modern best interests of the child standard, which, while appearing gender-neutral on paper, often carries the heavy baggage of these historical biases. This history isn't just about dusty law books. It's about the divorce gap. Studies show that while women often suffer a more immediate hit to their standard of living post-divorce, men frequently experience a more profound, long-term decline in physical health and social connection. By understanding the cultural history of how the American man went from the legal head of household to a litigant in a no-fault system, we can begin to see why modern divorce feels so chaotic. It is a collision between an 18th century view of family and a 21st century view of individual autonomy. In the next section, we are going to break down the Great Compression of the 1970s and 80s, where the financial stakes for men escalated from simple alimony to the complex division of retirement accounts, home equity, and even future earning potential. This is where the modern business of divorce truly began. To understand how we transitioned from simple alimony to the modern financial battlefield, we have to look at the 1970s as the decade where the American household was legally redefined from a social unit into a commercial partnership. Imagine you are a man named Michael in 1976. You have worked 15 years at a manufacturing plant in Ohio. You have a pension, a modest home, and a savings account. Under the older legal framework, if your marriage ended, you might pay a monthly sum of alimony to your ex-wife until she remarried. It was a straightforward income transfer. But as the 1970s progressed into the 80s, the legal system introduced a concept that changed Michael's life forever: equitable distribution. Before this shift, many states followed common law title rules. If Michael's name was on the deed to the house and the title of the car, those were his assets. The divorce court would then decide how much of his income should be diverted to his ex-spouse. However, the equitable distribution revolution changed the philosophy of the court from who owns this to who helped create this value. Suddenly, Michael's pension wasn't just his future safety net. It was a marital asset. The law began to view the stay-at-home spouse as a silent partner in a business. Every dollar Michael put into his 401k and every bit of equity that built up in the suburban home was now subject to a 50-50 split, regardless of whose paycheck funded it. This was a radical departure from historical trends. For the first time in American history, a man could enter a courtroom with a lifetime of accumulated wealth and leave with exactly half of his net worth evaporated in a single afternoon. This brings us to a critical case study that defined the 1980s, the O'Brien v. O'Brien case. This is a landmark moment that every man should understand because it pushed the boundaries of what constitutes property. In this case, a husband had worked toward his medical license during the marriage, while the wife contributed to their living expenses. When they divorced, the court ruled that the medical license itself was marital property. Think about the implications of that. The court wasn't just dividing the money in the bank. They were placing a dollar value on the man's future ability to earn. They calculated the potential outcomes of his entire career, discounted it to a present value, and awarded a portion of that invisible future money to the spouse. This set a precedent where a man's education, professional degrees, and even the goodwill of his business could be appraised and divided like a piece of furniture. As we move into the 1990s, the financial pressure on men shifted again with the federalization of child support. Imagine a man named David in 1992. Previously, child support was often a localized, sometimes inconsistently enforced matter. But with the passage of the Child Support Recovery Act and subsequent welfare reforms, the United States government turned child support enforcement into a high-tech, interstate operation. For David, this meant that his wages could be garnished automatically, his professional licenses could be suspended, and his passport could be revoked if he fell behind. The system became incredibly efficient at collecting, but it remained remarkably rigid. If David lost his job or suffered a health crisis in 1995, the debt continued to accrue. Unlike a credit card or a mortgage, child support debt in America is often non-dischargeable in bankruptcy. It is a financial obligation that follows a man to the grave, creating a secondary credit system where the state acts as the ultimate debt collector. By the early 2000s, we began to see the rise of the high-net-worth divorce and the weaponization of forensic accounting. In the modern era, particularly as we look at the landscape in 2026, the complexity has reached a fever pitch. A man is no longer just dividing a house and a car. He is dividing restricted stock units, digital assets, intellectual property, and complex tax carry-forwards. Case studies from the last decade show that the cost of the divorce process itself has become a significant drain on male wealth. When both sides hire forensic accountants to track down every cent spent during the marriage, the legal fees alone can consume 10 to 20% of the total marital estate. For a man who has spent 20 years building a small business, this isn't just a personal loss. It is a corporate liquidation. Let's look at the imagine-if scenario for a modern professional in 2026. You are 45 years old, a mid-level executive. You have a blended family. You are navigating the laws of a state like California or New York, where the cost of living is astronomical. Because of the historical trend toward dual-income households, you might assume the financial burden would be lower. However, the opposite is often true. The court now looks at the lifestyle established during the marriage. If you lived in a $2 million home and took 3 international vacations a year, the court's goal is often to maintain that standard of living for the lower-earning spouse. This creates a scenario where a man must essentially fund 2 high-end lifestyles on a single high-end salary. The math simply doesn't add up for many, leading to what sociologists call the divorce-induced poverty of the middle-class professional male. He earns too much to qualify for any help, but after taxes, child support, and alimony, his take-home pay is less than that of an entry-level worker. This financial evolution has created a psychological ripple effect. In the 1950s, a man's identity was tied to being the provider. In 2026, many men feel that the role of provider has been stripped of its status but kept for its liabilities. You are still expected to provide, but you no longer have the security of the family unit. This brings us to the most controversial aspect of the modern divorce machine: the intersection of money and time. For decades, child custody was often used as a lever in financial negotiations. While most states have moved toward a presumption of joint custody, the reality on the ground is often a pay-to-play system. The more time a man wants with his children, the more he may have to concede in the financial settlement. We are seeing a trend in 2026 where men are increasingly opting for prenuptial and postnuptial agreements not as an act of distrust, but as an act of survival. These documents are no longer just for the billionaire class. They are becoming standard for any man with a retirement account or a pre-existing business. But even these aren't bulletproof. Courts frequently throw out prenups if they are deemed unconscionable, or if the circumstances of the marriage change significantly. The legal landscape is a shifting sandbar, and the man of 2026 is trying to build a house on it. But the financial destruction is only half the story. There is another, more silent evolution that has taken place. One that doesn't involve bank accounts or deeds, but involves the very heart of the American home. While the law was busy reclassifying pensions and licenses as property, a much more profound shift was happening in the hallways of the family court regarding the one thing you can't put a price on: the children. If the 1980s were about the business of divorce, the 1990s and 2000s were about the battle for the father. Why did the tender years doctrine hang on for so long after women entered the workforce in record numbers? And why, in an era of supposed equality, does the every other weekend schedule remain the default setting in so many jurisdictions? In the next part, we are going to dive into the dark history of the custody wars. We will look at the psychological experts who shape the best interest standard and the shocking statistics that show what happens to a man's rights the moment he walks out the door. We are moving from the wallet to the nursery, and the reality there is even more complex than the financial ruins we've just explored. Are fathers truly equal in the eyes of the 2026 court, or are they still just seen as a walking paycheck? The answer lies in a series of legal maneuvers that most men never see coming until it's too late. The transition from the father as the legal head of the household to the father as a secondary visitor is one of the most jarring shifts in American social history. To understand the current climate of 2026, we have to look at the death of the paternal preference. In the early 19th century, children were legally considered the responsibility of the father because he held the economic means to provide. But as the Industrial Revolution moved men out of the home and into factories, a new psychological theory emerged called the tender years doctrine. This doctrine suggested that during a child's early formative years, the mother's influence was biologically and emotionally superior. What began as a well-intentioned effort to protect infants eventually hardened into a rigid legal bias that dominated the 20th century. Imagine a man named Robert in 1955. Robert is a devoted father, but when his marriage dissolves, the court operates under the assumption that he is essentially an auxiliary parent. The tender years doctrine meant that unless Robert could prove his wife was fundamentally unfit, meaning he had to prove she was a danger to the children, custody would automatically go to her. Robert was relegated to the standard visitation schedule, every other weekend and perhaps a Wednesday evening dinner. This created a generation of weekend dads, a cultural archetype that deeply wounded the American male psyche and established a historical trend where a man's value was measured by his child support check, rather than his presence at the dinner table. By the 1970s and 80s, the tender years doctrine was technically phased out in favor of the best interests of the child standard. On the surface, this looked like progress. The law became gender neutral. It stated that the court would look at a variety of factors, stability, emotional bonds, and the ability to provide, to determine the best placement. However, historical trends show that gender neutral, in theory, often remained maternal preference in practice. Judges, many of whom were raised in the earlier era, continued to default to the mother as the primary caregiver. Let us look at a case study from the late 1990s that highlights the primary caretaker loophole. Courts began to focus on who performed the daily tasks, who made the school lunches, who took the child to the doctor, and who attended the parent-teacher conferences. For the American man who was working 60 hours a week to fund the suburban dream, this was a catch-22. By being a successful provider, he was inadvertently disqualifying himself from being the primary caretaker. The very labor he performed to support his family was used as evidence that he was absent, and therefore less deserving of 50-50 custody. This created a structural inequality where the breadwinner model of masculinity was penalized in the family court system. In 2026, we are seeing the fallout of this system through the rise of the shared parenting movement. Currently, over 20 states have passed or are considering legislation that creates a rebuttable presumption of equal shared parenting. This means the court starts at a 50-50 split and only deviates if there is a compelling reason. But even in 2026, the implementation is inconsistent. Imagine a professional named James in a state without this presumption. James wants to be an equal parent, but he is met with the status quo argument. If the couple has been separated for 6 months and the mother has had the children 80% of the time during that period, the court often refuses to change the schedule to avoid disrupting the children's lives. This creates a race to the courthouse, where the parent who secures the children first often wins the long-term custody battle by simply letting the clock run out. We must also address the psychological tool known as parental alienation, a term coined by Richard Gardner in the 1980s. While controversial in some legal circles, it describes a very real phenomenon many men face: the systematic disparagement of the father by the other parent to turn the children against him. In the high-stakes environment of a 2026 divorce, a man's relationship with his children can become a piece of leverage. If a child begins to refuse visitation, the court often lacks the resources or the will to enforce the father's time, leading to a slow-motion erasure of the paternal bond. This isn't just a legal failure. It is a public health crisis for men, as the loss of access to children is one of the leading indicators for male depression and suicide post-divorce. Step by step, the modern custody process has become a psychological gauntlet. First comes the temporary orders hearing, which often sets the tone for the next 2 years. If a man loses ground here, he is fighting an uphill battle. Next comes the guardian ad litem, or a court-appointed evaluator. This is a third-party professional who interviews the family and makes a recommendation. For the father, this means his entire life. His home, his girlfriend, his hobbies, his discipline style is put under a microscope. Case studies show that a single negative comment in an evaluator's report can cost a man years of parenting time and tens of thousands of dollars in legal fees to overturn. Then there is the financial intersection of custody. In many U.S. states, child support is calculated based on the number of overnights each parent has. This turns a child's time into a currency. If a father moves from 30% time to 50% time, his child support obligation might drop significantly. This creates a perverse incentive for the higher-earning spouse to fight against shared parenting, not out of concern for the child, but to protect the monthly transfer of wealth. It is a cynical reality of the 2026 system that we must acknowledge. The best interests of the child is often inextricably linked to the best interests of the payee. The modern American man in 2026 is also navigating the digital custody landscape. We are seeing more cases involving the monitoring of parenting apps, the GPS tracking of children's devices, and the use of social media posts as evidence of instability. If a man goes out for a drink with friends on his off weekend and posts a photo, it can be used in court to paint him as a partier, rather than a parent. The level of surveillance is unprecedented in human history. Every text message, every Venmo transaction, and every Ring doorbell video is a potential exhibit in a trial that could determine if you see your son or daughter for 4 days a month or 14. This leads us to the evolution of the fatherhood identity. In the 21st century, men are now expected to be as domestically involved as women. Yet the legal system is still catching up to this social reality. We are in a gray zone, where the expectations on men have increased, but their legal protections have remained largely stagnant. The result is a profound sense of disenfranchised grief, a type of mourning that isn't socially recognized. When a man loses his home and his daily access to his children, society often tells him to be tough and move on. But the legal system continues to remind him of his loss every time a payment is deducted from his account. But there is a new shadow looming over the American divorce landscape, one that is even more volatile than the custody battle. It is the rise of the silver divorce and the gray divorce phenomenon. As the baby boomer and Gen X generations hit their 50s and 60s, the rules are changing again. What happens when the children are gone, but the assets are at their peak? What happens when a man has spent 40 years building a legacy, only to see it dismantled at the finish line of his career? In the next part, we are going to look at the devastating financial and social impact of late-life divorce. We will explore why alimony for life is making a comeback in certain jurisdictions, and how the post-parental divorce is creating a new class of socially isolated men. The battle for the nursery is over for these men, but the battle for their retirement is just beginning. The phenomenon of gray divorce represents a seismic shift in the American domestic landscape, specifically targeting the demographic of men aged 50 and older. Historically, divorce was a young man's game, often occurring within the first 7 to 10 years of marriage. However, since the early 1990s, the divorce rate for those over 50 has doubled, and for those over 65 it has tripled. This is not just a statistical anomaly. It is a fundamental restructuring of the male sunset years. For the American man in 2026, the prospect of a late-life divorce is the ultimate stress test for his financial and emotional legacy. Imagine a man named Richard. It is 2026, and Richard is 62 years old. He has spent 35 years climbing the corporate ladder in the telecommunications industry. He has a substantial 401k, a primary residence that is nearly paid off, and a modest portfolio of rental properties intended to fund a retirement of travel and leisure. When his wife of 30 years files for divorce, Richard isn't just facing the loss of a partner. He is facing the liquidation of his entire life's work at the exact moment he lacks the time to rebuild it. In the legal world, this is known as the diminishing returns of the career arc. Unlike a 30-year-old who has decades of earning potential ahead, Richard is at the tail end of his peak income years. The financial mechanics of a gray divorce are brutal for men because of the way state laws treat long-term marriages. In many jurisdictions, a marriage lasting 20 years or more triggers a different set of rules regarding spousal support, often referred to as indefinite or permanent alimony. While many states have moved toward rehabilitative alimony, temporary support designed to help a spouse get back on their feet, long-term marriages are still frequently subject to the rule of maintaining the standard of living. For Richard, this could mean that a significant portion of his pension and Social Security benefits are diverted to his ex-wife for the rest of his life. Consider the case study of asset division regarding the Qualified Domestic Relations Order, or QDRO. For many men, their retirement account is their largest single asset. During a gray divorce, a QDRO is issued by the court to split these tax-advantaged accounts. This isn't as simple as withdrawing cash. It involves complex tax implications and the permanent bisection of a man's future safety net. If Richard's 401k was valued at $2 million, it is now $1 million. But the cost of living for a single man in 2026 is significantly higher than half the cost of a couple. He loses the economies of scale that marriage provides: shared utilities, shared insurance, and shared housing costs, while his income is slashed by the court-ordered support. Furthermore, we must analyze the social isolation that specifically plagues men in this category. Historical trends show that in American marriages, women often serve as the social directors of the family. They maintain the ties with extended family, coordinate friend groups, and manage the couple's social calendar. When a man like Richard divorces at 62, he often finds that his social circle evaporates. He frequently loses touch with the couple friends he has known for decades. This leads to a phenomenon called the lonely bachelor effect, where divorced men over 60 show significantly higher rates of cardiovascular disease and cognitive decline compared to their married or even widowed peers. For the man in 2026, divorce in the senior years is not just a financial hit, it is a biological one. The 2026 legal landscape has also introduced the complexity of the adult-child dynamic. Even though custody battles are over, the financial pressure of supporting adult children often exists. In a gray divorce, the division of assets often complicates the inheritance man had hoped to leave behind. We see case studies where men feel pressure to liquidate their own retirement security to ensure their adult children are not financially impacted by the split. This creates a generation of men who are working into their 70s not because they want to, but because the court-mandated division of their wealth has made retirement an impossibility. Step by step, the gray divorce process for a man involves a specialized form of forensic discovery. In 2026, this includes the valuation of health insurance. For a man in his 60s, the cost of securing private health insurance post-divorce but pre-Medicare can be astronomical. This is a hidden cost that many men fail to factor into their settlement negotiations. When the court orders a man to provide COBRA coverage or a private policy for an ex-spouse as part of the support package, it can act as a massive, invisible tax on his remaining income. Another critical factor is the home equity trap. Often, the wife is awarded the family home in exchange for the husband keeping his retirement accounts. In a high-interest rate environment like 2026, the man is then forced to re-enter the housing market at the peak of his age and the bottom of his liquidity. He goes from owning a 5-bedroom suburban home with a 3% mortgage to renting a 2-bedroom apartment or buying a condo at a 7% interest rate. This shift in housing status often carries a heavy psychological weight, signaling a loss of status and a regression in his life's progress. We also see the rise of the post-parental identity crisis. For many American men, their identity for 30 years was tied to being the provider and the father figure within a specific household. When that household is dissolved, and the children are gone, the man is left in a vacuum. The cultural history of the 20th century didn't prepare him for a third act as a single individual. He is navigating a world of dating apps and social media that feels alien, while his legal obligations remain rooted in a marriage that no longer exists. This is the era of the silver nomad, where an increasing number of men are opting for mobile lifestyles or downsizing to extreme degrees just to maintain a sense of financial control. The data also suggests a disturbing trend in the healthcare of these men. Without a spouse to encourage regular checkups or monitor diet and exercise, divorced men in their 60s often experience a rapid decline in health. This creates a secondary financial crisis, rising medical costs at a time when their income is at its lowest. In 2026, the intersection of the healthcare system and the family court system has created a perfect storm for the aging male. As we look at the historical trajectory, the gray divorce is the final evolution of the no-fault revolution. It is the moment where the long-term contract of marriage is tested against the modern desire for individual fulfillment. But for the man, the price of that fulfillment is often his legacy. He is the one who built the estate, and he is the one who sees it partitioned at the finish line. But as devastating as the financial and social costs are for the older man, there is a burgeoning movement in the 2026 legal sphere that is beginning to push back. It is a movement centered on the concept of domestic reform and the reevaluation of what a man truly owes in the 21st century. Before we can understand where the law is going, we have to look at the most controversial and misunderstood aspect of the entire divorce machine: the actual math behind the money. In the next part, we are going to dive deep into the hidden formulas of the child support and alimony guidelines. We will reveal how the software used by the courts actually calculates a man's worth, and why the numbers often seem to defy logic. We are going to expose the spreadsheet that determines your future, and for many men, what they see inside that software is more frightening than any courtroom drama. To understand the financial reality for a man in 2026, you have to look past the judge and the mahogany bench and look directly at a computer monitor. In the vast majority of United States jurisdictions, the human element of financial adjudication has been replaced by standardized software algorithms. Programs like Disamaster or various state-specific child support calculators have become the silent architects of a man's post-divorce life. These programs operate on a cold mathematical logic that often ignores the granular reality of a man's daily expenses, focusing instead on gross income, tax filing status, and a specific percentage of time spent with the children. Imagine a man named Mark in 2026. Mark is a software engineer earning $140,000 a year in a mid-sized American city. To Mark, that sounds like a comfortable middle-class existence. But once the court's algorithm begins its work, Mark's perspective shifts rapidly. The software doesn't start with Mark's net take-home pay. It starts with his gross income. It then applies a standardized tax deduction that might not reflect Mark's actual tax liability. The algorithm then looks at his ex-spouse's income, or lack thereof, and begins a process of income equalization. In many states, the formula is designed to ensure that the two households have a relatively similar standard of living. But the math often fails to account for the fact that Mark now has to pay for a second set of rent, utilities, and insurance on a single depleted income stream. This brings us to a historical trend that has reached its peak in 2026: the imputation of income. This is one of the most controversial maneuvers in the family court system. Imagine Mark's ex-wife has not worked outside the home for 5 years. Mark might assume that since she is capable of working, the court will expect her to contribute. However, the court often assigns or imputes an income to her based on her past education or minimum wage. If the court decides she can earn $30,000 a year, the software calculates Mark's obligations as if she is already making that money. But if she doesn't actually get a job, or if she stays underemployed, the financial burden remains firmly on Mark's shoulders. Conversely, if Mark decides to take a lower-paying job to reduce his stress or spend more time with his kids, the court can refuse to lower his payments, imputing his previous $140,000 salary to him indefinitely. The law essentially locks him into a high-stress career path regardless of his personal well-being. Let's look at a case study regarding the 40% threshold. In many state guidelines, there is a cliff in the math. If a father has his children 39% of the time, he pays a certain amount of child support. If he crosses the threshold to 40% or 50%, the child support amount can drop significantly. This creates a scenario in 2026 where the legal battle over a single Tuesday night or every other Thursday is not about the child's development, but about the math. A man finds himself litigating over 24 hours of time because those 24 hours represent a $500 a month swing in his disposable income. This is the monetization of fatherhood, and it is a direct result of the shift from judicial discretion to algorithmic mandate. Step by step, the way these formulas are constructed reflects a historical legacy of the breadwinner model that hasn't fully caught up to the 2026 economy. For example, many calculators do not factor in the cost of a man's commute, his mandatory professional fees, or the higher cost of living in certain urban areas. The formula assumes a static world. If Mark's rent increases by 20% due to inflation in 2026, the child support formula does not automatically adjust to give him more breathing room. He must file a motion for modification, which requires a significant change in circumstances and, more importantly, thousands of dollars in new legal fees. For many men, the cost of asking the court for relief is higher than the relief itself. We also have to discuss the concept of the add-on. In the modern American system, the base child support number is often just the beginning. On top of that, the algorithm typically splits the cost of health insurance, uninsured medical expenses, and work-related childcare. In 2026, as the cost of childcare in the United States has soared, these add-ons can often equal or exceed the base support amount. A man might see a court order for $1,200 in support, but by the time he pays 50% of a high-end daycare and the premium for the family health plan, he is looking at $2,500 a month in out-of-pocket expenses. Another critical factor is the tax treatment of these payments. Historically, alimony was tax-deductible for the payer and taxable for the recipient. This allowed the higher earner, usually the man, to shift some of the tax burden. However, following the Tax Cuts and Jobs Act, the federal government flipped this. Alimony is no longer deductible for the man, but the recipient receives it tax-free. In 2026, this means a man is paying his support with after-tax dollars. If he is in a high tax bracket, he has to earn nearly $1.50 for every $1 he sends in support. This hidden tax hit has significantly reduced the net wealth of divorced men across the country, making the recovery period after a split much longer than historical trends suggested. Imagine if you are a man in 2026 who receives a bonus or a commission. Most court orders now include what is known as a Smith-Ostler or a bonus table. This means that a percentage of every extra dollar you earn through hard work, overtime, or a year-end performance review is automatically diverted. This creates a massive disincentive for professional growth. We see case studies where men intentionally pass over promotions because the increased responsibility and stress would only result in a marginal increase in their actual take-home pay after the court-ordered deductions. The system, designed to protect the children, can inadvertently cap a man's ambition. The algorithm also struggles with the rise of the gig economy and non-traditional income. For a man who is an independent contractor or an entrepreneur in 2026, the court often looks at his gross receipts rather than his actual profit. Proving legitimate business expenses to a family court judge is notoriously difficult. The court tends to view business deductions with suspicion, often adding back expenses like home office use or travel into the man's income for support purposes. This leads to a scenario where a man is legally ordered to pay support based on money he never actually put in his pocket. This mathematical straitjacket is why so many men feel the system is rigged. It isn't necessarily that the judge is biased. It's that the formula is a blunt instrument used to solve a surgical problem. The historical trend toward these guidelines was meant to provide consistency and reduce litigation, but it has instead created a new form of high-stakes gambling, where the variables you enter into the software determine the next 18 years of your life. But what happens when the money isn't just about child support? What happens when we move into the realm of the permanent payout? There is a specific legal mechanism that has survived the transition into the modern era, one that many men believe should have been abolished decades ago. It is the ghost of the 19th century marriage contract, reimagined for the modern age. In the next part, we are going to look at the survival of alimony in 2026. We will explore why some men are still paying for their ex-spouse's lifestyle decades after the marriage ended, and the movement that is currently fighting to end permanent spousal support once and for all. We are moving from the software to the long-term debt, and the stories here will change everything you thought you knew about the cost of saying I do. The 2026 landscape for spousal support, what we historically call alimony, is currently caught in a tug-of-war between 19th century tradition and 21st century reform. For the American man, this is the part of the divorce where the debt becomes structural. While support is focused on the offspring, alimony is focused on the partner, and the historical trend has shifted from a concept of mercy to a concept of lifestyle entitlement. To understand where we are today, we must look at the recent massive legislative shifts in states like Florida and Massachusetts, which serve as case studies for the rest of the nation. Imagine a man named Stephen in 2026. Stephen was married for 22 years. He worked as a middle manager while his wife stayed home to raise their 3 children. In the old legal world, Stephen might have been facing a permanent alimony order, meaning he would be writing a check every single month until either he died or his ex-wife remarried. This was the lifetime contract model. But in 2026, Stephen is living in the era of durational alimony. Because of the landmark 2023 reforms in Florida and similar movements across the U.S., the concept of permanent, forever alimony is being systematically dismantled. For Stephen, this means his obligation is now capped at a specific percentage of the marriage's length, likely 75%. There is finally a light at the end of the tunnel, but the tunnel is still 2 decades long. Plus 2. The modern alimony math is governed by 2 words: need and ability. In 2026, the court's first step is to establish if the lower-earning spouse has an actual financial need, and if the higher earner has the ability to pay. On the surface, this sounds fair. However, case studies show that need is a highly subjective term. In high-asset divorces, the court often defines need not as the cost of food and shelter, but as the cost of maintaining the marital standard of living. If the couple lived in a 5,000 square foot home and belonged to a country club, the court may determine that the ex-spouse needs $10,000 a month to remain in that same social stratum. For the man, this means he is often financing a lifestyle for someone else that he can no longer afford for himself. Plus one. Step by step, the 2026 alimony process follows a strict new hierarchy. First, the court looks at the 35% cap. In states like Florida, alimony cannot exceed 35% of the difference between the parties' net incomes. If Stephen makes $200,000 and his ex-wife is imputed to make $40,000, the gap is $160,000. The 35% cap means Stephen's maximum exposure is around $56,000 a year. This cap is a massive win for the predictability of male finances, but it still represents a significant portion of after-tax income, especially since the 2018 tax changes made alimony non-deductible for the payer. Stephen is paying that $56,000 with money that has already been taxed, meaning he actually has to earn closer to $80,000 just to cover the alimony. Plus two. We must also explore the supportive relationship loophole. Historically, alimony ended upon remarriage. This led to a trend where ex-spouses would live with new partners for years without marrying to keep the alimony checks flowing. In 2026, many states have strengthened laws regarding cohabitation or supportive relationships. If Stephen can prove that his ex-wife is living with a new partner, sharing expenses and functioning as a family unit, he can petition to reduce or terminate his payments. However, the burden of proof is on the man. This has given rise to a niche industry of private investigators in 2026 who specialize in cohabitation surveillance. A man might spend $10,000 on a PI just to save $50,000 in future alimony payments. It is a cynical, high-stakes game of cat and mouse played out in suburban driveways across America. Plus one. Another critical development in 2026 is the retirement clause. For decades, men were terrified that they could never stop working because their alimony order didn't have an expiration date. The 2026 legal standard in many states now explicitly allows a man to file for termination of alimony when he reaches normal retirement age, as defined by the Social Security Administration. Imagine if Stephen wants to retire at 67. Under the new laws, his retirement is considered a material change in circumstances. The court can no longer force him to work just to maintain an alimony payment. This is a fundamental shift in the cultural history of divorce, moving from a model of lifetime servitude to a model of transitional support. Plus two. However, we must address the bridge the gap and rehabilitative alimony types that are becoming more common for younger men. If a marriage lasted only 5 years, a man in 2026 isn't looking at long-term support, but he may be ordered to pay bridge the gap alimony. This is a short-term, non-modifiable payment intended to help the other spouse transition to single life. It usually lasts no more than 2 years. Then there is rehabilitative alimony, which is tied to a specific plan, like the ex-spouse going back to school to get a nursing degree. For the man, this is often the most frustrating form of support, as he is essentially paying for his ex-wife to become more employable so that he can eventually stop paying her. Plus two. The 2026 landscape has also seen the rise of the alimony buyout. Instead of monthly payments, many men are opting for a lump sum settlement. Imagine if Stephen has a large amount of equity in the home or a significant brokerage account. He might offer his ex-wife an extra $300,000 upfront in exchange for a complete waiver of alimony. This is a risky move. If Stephen pays the lump sum and his ex-wife remarries 2 months later, he cannot get his money back. But for many men, the psychological freedom of not having a monthly link to their ex-spouse is worth the financial risk. It is an exit fee that allows them to close the chapter entirely. This evolution of alimony reflects a broader societal shift, the realization that the 1950s homemaker model is becoming an outlier. With more women in the workforce and more men taking on domestic roles, the justification for lifelong spousal support is eroding. Yet the transition is messy. We are in a period where a man can still be held to 19th century standards of chivalry and provision, while living in a 21st century economy of dual earners and high inflation. The gender pay gap is often cited in these courtrooms to justify higher payments, even when the individual earners in the case are on equal footing. But even as the rules for alimony are being rewritten, a new and much more invasive force is entering the American home. While we've talked about the money and the time, we haven't talked about the social credit of divorce. In 2026, the courtroom isn't just looking at your bank account, they are looking at your hard drive. The rise of digital forensics in divorce has turned every text, every post, and every private message into a potential weapon that can override even the most settled alimony formulas. In the next part, we are going to look at the weaponization of the digital footprint. We will explore how at-fault divorce is making a backdoor comeback through social media, and how a single deleted message can cost a man his entire legal strategy. The math is solid, but the metadata is where the real danger lies. In the year 2026, the concept of a private life has effectively been abolished within the American family court system. While we technically live in an era of no-fault divorce, where the legal reason for the split doesn't supposedly matter, the reality on the ground has shifted toward a new shadow version of fault based on digital evidence. We are seeing a historical trend where a man's digital footprint, spanning back a decade or more, is being strip-mined for data to influence custody arrangements and financial distributions. This is the era of the electronic discovery, and for many men, it is a legal minefield they didn't even know they were walking through. Imagine a man named Thomas in 2026. Thomas believes he is entering a standard no-fault proceeding. He has been a good provider and a present father. However, during the discovery phase, his ex-wife's legal team subpoenas his entire digital life. This isn't just his emails. We are talking about his Google Maps location history, his Amazon purchase records, his Netflix viewing habits, and every single like on social media. In 2026, the court doesn't just want to know what Thomas says he did. They want to see the metadata of his life. If Thomas claimed he was working late but his Tesla's GPS shows he was at a sports bar, that metadata is used to impeach his credibility. In the modern courtroom, a man's character is no longer judged by his testimony, but by the synchronization of his devices. The weaponization of the digital footprint has led to the rise of the digital forensic auditor. This is a professional who specializes in extracting deleted data. Case studies from 2024 and 2025 show that many men believe deleting a message or a thread solves the problem. In reality, the act of deleting a message after a divorce filing is often viewed by the court as spoliation of evidence. Imagine if Thomas, in a moment of frustration, sent a heated text message and then deleted it. If the forensic auditor finds a trace of that deletion, the judge can apply an adverse inference. This means the court can legally assume the deleted message contained the worst possible information. For a man in 2026, the smartphone in his pocket is either his best witness or his most dangerous informant. Furthermore, the role of social media in 2026 has evolved into a tool for lifestyle auditing. We see historical trends where men are caught in a financial pincer movement. A man might argue in court that he cannot afford a certain level of alimony due to business downturns, but if his Instagram shows him at a high-end steakhouse or wearing a new luxury watch, the court uses that public broadcast to justify a higher payment. The legal system has moved from looking at bank statements to looking at the optics of social media. This has created a culture of digital paranoia. Men are being advised by counsel to go dark on social media for the duration of their cases, but even this is often too late. The Wayback Machine and archived screenshots from disgruntled acquaintances mean that a man's past is never truly buried. Let us look at a case study involving the Internet of Things. In 2026, our homes are filled with smart devices. We have seen cases where smart doorbell footage is used to track exactly what time a father returns a child from visitation, down to the second. If the order says 6 p.m. and the Ring camera shows 6:03 p.m., it is logged as a violation. We've seen smart thermostat data used to argue that a father's home is uncomfortably cold for a toddler, or Peloton workout data used to prove a man has more free time than he claimed during his primary caretaker deposition. This level of granular surveillance was unimaginable 20 years ago, but in 2026 it is standard practice. Every sensor in a man's life is a potential witness for the prosecution. Step by step, the discovery process now involves a social media audit. This isn't just looking for bad behavior like drinking or dating. It is about pattern of life analysis. If a man's LinkedIn shows him networking for a new job, the court might use that as evidence of future earning potential to increase his support obligations. If his Facebook shows him engaging in a risky hobby like motorcycling, it can be used to argue for restricted visitation rights based on judgment and safety concerns. The historical trend here is the total loss of context. A single photo taken out of context can derail 2 years of legal strategy and cost a man thousands in additional mediation fees to explain away a moment that shouldn't have mattered. This brings us to the most dangerous development in 2026. The use of AI-driven sentiment analysis in family law. New software programs are being used by law firms to scan thousands of a man's text messages and emails to determine his emotional volatility. The AI assigns a score based on his language, If a man uses aggressive or controlling language in his private communications, that score is presented to a judge as an objective measure of his fitness as a co-parent. The problem is that AI often fails to understand sarcasm, cultural nuances, or the sheer stress of a high-conflict divorce. A man who is simply venting to a friend about a difficult day can be flagged as high risk by a machine. We also have to address the digital breadcrumb in financial hidden asset searches. In the age of cryptocurrency and digital wallets, men often think they can shield assets from the 50-50 split. However, the forensic tools available in 2026 are incredibly sophisticated. A single transaction on a public ledger, or a seed phrase found in a cloud backup, can lead to a finding of fraud on the community. When a man is caught hiding digital assets, the penalties are far more severe than if he had simply been honest. Courts in states like California and New York have the power to award 100% of the hidden asset to the other spouse as a punitive measure. The digital world is not the Wild West it once was. It is a ledger that never forgets and rarely forgives. Imagine if you are a man in 2026 who has been through a clean divorce, only to have your ex-spouse file for a modification 3 years later because of something she saw on your LinkedIn or a travel blog. The finality of judgment is becoming a myth. The constant stream of digital information means that your ex-spouse and her legal team can monitor your material change in circumstances in real time. If you get a promotion, they know. If you buy a new car, they know. If you start a successful side hustle, they see the ads. This persistent digital connection keeps the divorce live indefinitely, preventing men from ever truly achieving the psychological and financial closure that the law used to provide. The cultural history of divorce has moved from the village gossip of the 1800s to the global database of 2026. A man's reputation used to be built in his community. Now it is a searchable index. This shift has forced a new type of defensive living for the American male. But as we navigate this world of censors and sentiment analysis, an even more fundamental question is rising to the surface. It is the question of the new masculinity in the wake of the divorce machine. After the assets are divided, the custody is settled, and the digital footprint is scrubbed. Who is the man that remains? We are seeing a massive psychological shift in how men view the institution of marriage itself. The marriage strike and the rise of the MGTOW philosophy are not just internet subcultures. They are becoming mainstream reactions to the historical trends we have discussed. In the next part, we are going to look at the future of the contract. We will explore why marriage rates in the US are hitting historic lows in 2026, and what the alternative models of commitment look like. Is the traditional American marriage becoming an obsolete legal risk for men? Or is there a way to reinvent the partnership for a new century? We are moving from the courtroom to the future of the American family unit, and the stakes couldn't be higher. The statistical reality of 2026 is that the American marriage rate has reached its lowest point in recorded history. This is not a coincidence or a temporary cultural fad. It is a direct response to the historical trends and legal outcomes we have explored over the last 7 parts. For the American man, the cost-benefit analysis of the traditional marital contract has fundamentally shifted. We are seeing a widespread phenomenon often termed the marriage strike, where men are increasingly viewing the legal institution of marriage as a high-liability contract with diminishing social returns. Imagine a man named Brian in 2026. Brian is 32, successful, and in a long-term committed relationship. In previous generations, the social pressure for Brian to marry would be overwhelming. But Brian has watched his father lose 50% of his net worth in a 2018 divorce, and seen his older brother spend $40,000 in legal fees just to maintain a 50-50 custody schedule. Brian is part of a growing demographic that chooses commitment without contract. For men like Brian, the state's involvement in their romantic life is seen as an unnecessary risk. This shift is creating a new cultural history where the gold standard of the nuclear family is being replaced by flexible, private agreements that bypass the family court system entirely. To understand this movement, we have to look at the rise of the co-parenting agreement among unmarried couples. In 2026, many men are choosing to have children with partners without the legal framework of marriage. However, they are discovering that the law has evolved to meet them there. Case studies in states like Washington and Oregon show that committed intimate relationship laws are being used to apply divorce-like asset division to couples who never even said, "I do." This is a critical wake-up call for the modern man. You cannot simply opt out of the system by avoiding a wedding. If you live like you are married, share bank accounts like you are married, and present yourselves as married, The court in 2026 may treat you as married when the relationship dissolves. Step by step, the new masculinity is defined by a move toward radical self-protection. This has birthed the prenuptial revolution. In the 1990s, asking for a prenup was seen as an insult or a sign that the marriage was doomed. In 2026, it is increasingly viewed as a standard piece of financial hygiene. We are seeing men in their 20s, who have very few assets, signing prenups that focus on future growth clauses. They are protecting the businesses they haven't started yet, and the intellectual property they haven't created. This is a case study in defensive law. Men are no longer waiting until they have wealth to protect it. They are building the fortress before the first brick is even laid. But the marriage strike isn't just about the money. It's about the social contract. Historically, marriage provided a man with a clear identity, the protector and the provider. In 2026, these roles have been hollowed out by economic reality and social change. When women are often out-earning men in urban centers and the state provides the ultimate protection through the legal system, many men feel like guests in their own lives. This has led to the rise of the living apart together, or LAT model. Imagine if Brian and his partner live in separate apartments but remain in a committed, monogamous relationship. This model is skyrocketing in 2026 among men over 40. It preserves a man's autonomy, protects his assets from commingling claims, and ensures that if the relationship ends, the exit is a personal matter, not a state-mandated liquidation. We must also address the MGTOW, or men going their own way philosophy. While often marginalized in mainstream media, the core tenet, that a man should find fulfillment and purpose outside of the traditional family structure, is becoming a quiet reality for millions. Data from 2025 indicates a significant increase in solo male homeownership and a surge in the solo travel and solo hobby industries. Men are reinvesting the capital they would have spent on a wedding, a diamond ring, and a suburban mortgage into their own personal development and health. This is a radical departure from the 20th century model of the self-sacrificing father. The 2026 man is increasingly self-sustaining. Let's look at an imagine-if scenario that is becoming common in 2026. Imagine you are a man who decides to have a child via surrogacy as a single father. This was once a path reserved for the ultra-wealthy or specific subgroups. Today, professional men are choosing solo fatherhood to avoid the potential outcomes of a high-conflict custody battle later. By removing the partner from the legal equation at the start, they ensure 100% custody and zero risk of alimony. This is the ultimate open loop in the cultural history of the family. Men are so wary of the divorce machine that they are reinventing the very definition of family to exclude the possibility of a legal split. However, there is a counter-movement. We are seeing the rise of covenant marriage in several states, where couples voluntarily agree to limit their own ability to get a no-fault divorce. This is a return to fault-based logic, where the man and woman agree that they can only split in cases of adultery or abuse. For the men choosing this in 2026, it's about seeking a higher level of security. They want a contract that is harder to break because they believe the ease of modern divorce is what makes it so dangerous. They are looking for a traditional refuge in a no-fault world. The historical trend shows that when a system becomes too high risk, the participants either leave or change the rules. The American man in 2026 is doing both. We are seeing a bifurcation of commitment. On one side, you have the contractualists, who use prenups and trusts to treat marriage like a corporate merger. On the other, you have the minimalists who avoid the state entirely. The middle ground, the traditional handshake in a prayer marriage of the 1950s, is disappearing. It is seen as too legally thin to survive the thick complexity of modern family law. This brings us to the psychological rebranding of the divorced man. In the 1970s, a divorced man was often seen as a failure or a loner. In 2026, he is often viewed as a survivor. There is a burgeoning divorce recovery industry specifically for men that focuses on rebuilding the king. These programs don't focus on getting back into the dating pool. They focus on wealth recapture and paternal resilience. They teach men how to navigate the 2026 landscape as a unit of one. This is the final stage of the cultural history, the normalization of the post-family man. But as men pull back and reinvent their roles, a massive unintended consequence is beginning to ripple through the American economy. If men are no longer incentivized to provide and protect in the traditional sense, what happens to the productivity of the nation? What happens to the tax base when the breadwinner decides to work 30 hours instead of 60 because he doesn't want his bonus to be swallowed by a Smith-Osler table? In the next part, we are going to look at the economic ghost of the divorced man. We will explore how the quiet quitting of the American father is changing the U.S. labor market, and why the divorce machine might be accidentally sabotaging the very economy that funds it. The courtroom has changed the home, but the home is now changing the country. The economic ghost of the divorced man is a phenomenon that economists in 2026 are only beginning to quantify, but its roots trace back decades. Historically, the American economy was built on the back of the family man. In the 1950s and 60s, the social contract was simple. Work hard, climb the corporate ladder, and your increasing wages would provide a stable, upwardly mobile life for your wife and children. This incentive structure drove unprecedented productivity. But as we move deeper into 2026, we are witnessing a fundamental break in that engine. When the legal system transforms a man's labor into a communal asset that can be unilaterally divided, the motivation to produce at a high level begins to evaporate. Imagine a man named Christopher. It is 2026, and Christopher is a high-performing sales director in the pharmaceutical industry. Before his divorce, Christopher was the first one in the office and the last to leave. He chased every lead, traveled 3 weeks out of the month, and maximized his commissions. But after a bruising divorce where the court applied a Smith-Osler table to his earnings, Christopher realized that for every extra $10,000 he earned in commission, he only kept $3,000 after taxes, child support, and durational alimony. Christopher didn't quit his job, but he did something much more damaging to the macroeconomy. He checked out. He stopped chasing the high-stakes leads. He stopped volunteering for the grueling travel. In 2026, we call this the strategic de-escalation of the American male. The data suggests that Christopher is not an outlier. Case studies in 2025 and 2026 show a significant correlation between high-conflict divorce and a decline in male workplace productivity. Economists have noted a historical trend where divorced men are increasingly opting for the lifestyle career. They are trading high-stress, high-income roles for lower-paying jobs that offer more autonomy and less visibility to the court. If a man earns $75,000 a year in a low-stress job, his support obligations are manageable, and he has more time for himself. If he earns $250,000, he becomes a high-value target for litigation. The divorce machine has inadvertently created a ceiling on male ambition. This shift has a massive impact on the U.S. tax base. High earners like Christopher fund a disproportionate share of the tax revenue that supports infrastructure, schools, and social programs. When a million Christophers decide that the juice is no longer worth the squeeze, the entire economic system feels the tremor. We are seeing a decline in what was once called the breadwinner premium. Historically, married men earned more than single men, largely because they had the external pressure to provide. In 2026, that premium is disappearing. The divorced man has no incentive to be the hero of the corporate world when the spoils of his victory are distributed by a court-ordered algorithm. Step by step, we can see how this affects the housing market. For decades, the suburban American dream, the four-bedroom house with the white picket fence, was the primary driver of domestic consumption. This dream required two things: a stable marriage and a man willing to sign a 30-year mortgage. In 2026, the rise of the divorce machine has turned the family home from an investment into a liability. Men are increasingly wary of locking their capital into a primary residence that could be liquidated or awarded to an ex-spouse. This has led to the rise of the rental economy for men. Instead of buying a family home, divorced men are moving into high-end, single-occupancy rentals. This shift is cooling the traditional housing market and driving up the cost of urban rentals, creating a new set of economic winners and losers. Consider the imagine-if scenario of the small business owner. Imagine a man named David who owns a successful HVAC company with 15 employees. During his divorce in 2026, the court-ordered valuation of his business didn't just look at his bank balance. It looked at his goodwill and projected future earnings. To pay out his ex-wife's share of the business's value, David had to take out a high-interest loan against the company's equipment. This debt prevented him from hiring more staff or expanding to a new city. The divorce didn't just end a marriage, it stunted a local business. Multiply this by thousands of entrepreneurs across the United States, and you see how the divorce machine acts as a silent drag on small business growth. Furthermore, we must address the transfer of wealth problem. In 2026, Trillions of dollars are being transferred from the productive male workforce to the service sector of the divorce industry: lawyers, forensic accountants, mediators, and evaluators. This is what economists call deadweight loss. This money isn't being invested in new technology, education, or infrastructure. It is being burned in the friction of legal combat. A man who spends $100,000 on a divorce lawyer is $100,000 less likely to invest in a startup or save for his children's college tuition. The divorce machine is effectively a massive tax on the future of American innovation. The 2026 labor market is also seeing a rise in the gig-based executive. Men who previously held stable W-2 positions are moving toward 1099 consulting roles. This allows them to fluctuate their income more easily and maintain a level of financial opacity that is harder to achieve in a traditional corporate structure. While this gives the man more flexibility, it reduces the stability of the American workforce. Companies are finding it harder to retain experienced male leadership because those men are prioritizing legal and financial shielding over long-term corporate loyalty. We are also seeing the emergence of the international relocation trend. In 2026, a growing number of divorced American men are taking their remote work skills and moving to jurisdictions with a lower cost of living and more favorable tax treatments. This brain drain is a direct result of the high-cost, high-conflict nature of the U.S. divorce system. When a man feels that his own country's legal system has become predatory, he takes his talents and his capital elsewhere. This is the ultimate economic ghost. A man who is still working, still producing, but whose contributions have been lost to the American domestic economy. The cultural history of the 20th century was about the expansion of the American middle class through the stability of the family. The history of the 21st century is becoming a case study in the fragmentation of that class. The economic ghost of the divorced man is a warning sign. It tells us that you cannot have a thriving, high-growth economy if the primary producers feel that the rewards of their labor are disconnected from their own well-being and the well-being of their household. But there is one final piece of this puzzle. We have looked at the law, the money, the kids, and the economy, but we haven't looked at the man in the mirror. After all the battles are fought and all the checks are written, there is a profound psychological transformation that takes place. In the final part of this series, we are going to look at the Stoic rebirth. We will explore how men in 2026 are finally moving past the anger and the victimhood to find a new kind of power. We are going to look at the final decree, not the one from the judge, but the one a man gives himself. The divorce machine can take your house, your money, and your time, but there is one thing it can never touch unless you let it. We're going to show you exactly what that is, and how the most successful men in America are using their exit as an entrance to a life that the system can't control. The Stoic rebirth is the final stage of the American man's journey through the cultural history of divorce. By the time a man reaches this point in 2026, he has been through the structural liquidation of his assets, the algorithmic reduction of his fatherhood, and the digital auditing of his character. He has seen the legal system move from 19th century moralism to 21st century social engineering. But the men who emerge from this process not just intact but improved are those who realize that the divorce decree was actually a release of the psychological weight of an obsolete social contract. This is the moment where the man stops being a litigant and starts being the architect of his second life. Imagine a man named Marcus. It is 2026, and Marcus has just finished a 3-year legal battle. He lost the house, he pays $4,000 a month in combined support, and he sees his kids on a strict 50-50 schedule. In the first year, Marcus was consumed by resentment. He spent his nights reading legal forums and obsessing over the unfairness of the no-fault system. But then Marcus underwent a mental shift. He realized that while the court controlled his bank account, it had no jurisdiction over his focus, his fitness, or his future. Marcus adopted a philosophy of radical decoupling. He stopped viewing himself through the lens of a failed husband and started viewing himself as a high-performance individual who had just completed a very expensive but necessary corporate spin-off. The data on male recovery post-divorce shows a fascinating historical trend. Men who successfully navigate the aftermath in 2026 often experience a surge in what psychologists call post-traumatic growth. They become more health-conscious than they were during the marriage. We see case studies of men in their late 40s and 50s hitting their peak physical condition because they finally have the autonomy to control their environment, their diet, and their schedule. In 2026, the gym has become the new community center for the divorced man. It is where he reclaims the agency that was stripped from him in the courtroom. This isn't about vanity. It is about the physical manifestation of self-control. Step by step, the Stoic rebirth involves the purging of the provider's shame. For over a century, American men were told that their entire value resided in their ability to provide for a traditional nuclear family. When that family dissolves, the shame can be paralyzing. The 2026 man is deconstructing this. He is learning to separate his financial obligations from his self-worth. He pays his support not because he is being punished, but because it is a contractual obligation he is clearing off his balance sheet. By treating alimony and child support as a business expense rather than a moral failure, he removes the emotional leverage the system has over him. This is the final decree of the mind. The refusal to let a monthly bank transfer dictate your happiness. Furthermore, we must look at the new paternalism. In 2026, the most successful divorced fathers are those who have moved past the visitor mentality. Instead of mourning the time they lost, they maximize the time they have. Case studies show that fathers with 50-50 custody often develop deeper, more intentional relationships with their children than they had when they lived in the same house full-time. Because the time is limited and hard-won, it becomes high quality. These men are teaching their sons and daughters a new model of resilience. They aren't hiding the reality of the situation. They are demonstrating how a man handles adversity with dignity. This is the cultural shift from the broken home to the dual-lead household. Let us look at an imagine-if scenario regarding the second career of the 2026 man. Imagine you are a man who has fulfilled his durational alimony and whose children have aged out of the support system. You are now 55 years old. Historically, this man was seen as washed up, but in 2026, this is the golden exit. With zero legal liabilities and decades of professional experience, these men are launching Phase 2 ventures. They are starting consultancies, investing in passion projects, and traveling the world. They have the wisdom of age with the freedom of youth. The divorce machine tried to exhaust them, but it accidentally conditioned them for extreme endurance. We are also seeing the rise of the men's mastermind as a replacement for the traditional social structures that divorce often destroys. In 2026, these are not venting sessions about ex-spouses. They are high-level groups focused on estate planning, longevity science, and philosophical grounding. They are the modern equivalent of the old fraternal orders, but built for an era of digital transparency and legal risk. The historical trend here is the retribalization of the American male. Men are realizing that while the state-backed marriage contract is fragile, the bonds of brotherhood and shared purpose are resilient. The 2026 man is also redefining legacy. For the 20th century man, legacy was about the family name and the inheritance of the family home. For the 21st century divorced man, legacy is about the transmission of values and the protection of intellectual capital. He is setting up trusts that bypass the traditional probate and family court systems. He is using private contracts to ensure his wealth reaches his children directly, shielded from the volatility of future marital splits. He is playing a longer, more sophisticated game. He has learned that in a world of no fault, the only real security is the one you build yourself through private law and disciplined execution. The cultural history of divorce for men in America is a story of a massive power shift. We moved from an era where men held all the cards to an era where the system holds all the cards. But the end of that history is not the defeat of the man. It is the evolution of the man. The divorce machine is a filter. It strips away the passive, the unaware, and the entitled. But for the man who stays awake, who learns the rules, and who refuses to be broken by the math, it is a forge. It produces a version of masculinity that is more calculated, more autonomous, and more resilient than the one that entered the courtroom. As we look toward 2027 and beyond, the American man is no longer a monolith. He is a diverse group of individuals who are navigating a complex legal landscape with a new set of tools. The masterclass of divorce has taught him that the most important asset he owns isn't his house, his 401k, or his business. It is his unbreakable sovereignty. This is the part of you that no judge can garnish and no algorithm can calculate. It is the ability to walk away from the wreckage of a life and build something better, more honest, and more secure. The deep dive ends here, but the application begins now. Every man watching this is at a different point on the timeline. Some are just starting part 1, looking at the legal disclaimers. Others are in the thick of the financial spreadsheets of part 5. And some are standing where Marcus stood, looking at a blank slate. Regardless of where you are, the historical trends are clear. The system is a reality, but it is not a destiny. You have seen the case studies, you have heard the data, and you have traced the evolution of the American home. The question is no longer what will the system do to me, but what will I build with the freedom I found? In our next series, we are going to look at the architecture of the new American estate. We will dive into the specific legal structures, the international diversification strategies, and the private family contracts that the top 1% of men are using to bypass the divorce machine entirely. The rules of the game have changed, and it's time you learn the new playbook for the next decade. If you thought the history of divorce was intense, wait until you see the future of the protected man. The loop is open, and the next chapter is yours to write.